Good afternoon and welcome. I'm Kelly Weiss, the Executive Director of Marketing and Communications, and thank you for joining us today for the continuation of our Racial Justice Speaker Series. Wanted to outline just the format that we're going to have today. We will have our speaker give her talk, and then after that have time for questions. How we will do questions is you will send those to me through the chat, and I will then ask the questions for response. We are recording the event today. That will be posted to our website. And we are offering MCLE credits. You will receive that by email. Give us about a week to get that to you, but those are available as well. So I want to now introduce Dean Johnson to start our event.
Thank you, and thank you all for joining us for the first Racial Justice Speaker Series event of the spring semester and of the new year. We are very fortunate today to have Maryam Jamshidi, an assistant professor of law at the University of Florida, Levin College of Law, to speak with us today. Now, I want to mention a little bit about the Racial Justice Speaker Series, which is in its fourth semester at UC Davis School of Law. The series began in fall 2020 as a means of helping our community process the killings of George Floyd, Breonna Taylor, and others, while addressing the broader implications of systemic racism in the US criminal justice system. We also wanted to widen the perspective to show how racism and its terrible insidiousness affects all areas of law in American society. Besides racial justice in the criminal justice system, our speaker series thus far has encompassed family law, corporate law, immigration law, and the legal history of anti-Asian discrimination, among other topics. Today, Professor Jamshidi will address national security policies that undermine civil rights. Her talk is entitled Political Accountability for Discrimination National Security. We'll explore the ways the law can better support grassroots efforts to politically check the government for national security policies threatening the interests and rights of people of color. Professor Jamshidi teaches and writes in the areas of national security, public international law, the law of foreign relations, and tort law. Her scholarship examines the ways in which private law, particularly torts, shapes and is transformed by public laws touching on national security and international law matters. In exploring these dynamics, Professor Jamshidi's work draws on political and critical theory as well as sociology. Her scholarship has appeared or is forthcoming in the University of Chicago Law Review, the Southern California Law Review, the Washington University Law Review, and the University of Colorado Law Review. Before joining the Florida faculty, Professor Jamshidi served as an assistant professor of lawyering at NYU School of Law. She also worked for the leading Washington law firms, including White and Case, where she focused primarily on national security related issues and foreign relations law. Professor Jamshidi clerked for the Honorable Gladys Kessler of the U.S. District Court for the District of Columbia. Professor Jamshidi holds a JD from the University of Pennsylvania, a master's in political theory from the London School of Economics, and a bachelor's degree in political science from Brown. It's now my privilege to turn the virtual podium over to Professor Maryam Jamshidi. Welcome.
Thank you so much, Dean Johnson, for inviting me to speak today as a part of this very important series. I'm thrilled to be here. I wish it could have been in person. So I'm going to talk today about the executive branch and how the rule of law and popular politics work together to check or not to check that branch's national security powers, especially when it comes to national security programs that disproportionately impact people of color. So the executive branch, meaning the president and all the administrative agencies that are part of that branch, has become quite powerful over the last few decades, especially in the area of national security and foreign affairs. This power is reflected in part in the deference courts and Congress have often given to the executive's national security activities. It's also reflected in the few recent instances where Congress has tried but failed to check the presidency in the national security foreign affairs arena. Typically, we think of the separation of powers as being one of, if not the most important check on each of the federal government's branches. So if the courts and Congress aren't checking the president, then who is? According to some scholars, the rule of law, together with the power of popular politics, helps provide this check and keep the executive accountable, even when Congress and the courts can't do it or aren't doing it. Basically, what this theory means is that the rule of law shapes and propels efforts by regular people like you and me to check the presidency by using our political power, whether through elections, protests, or other kinds of political advocacy. Obviously, this raises a question. What do we mean by the rule of law? Basically, it means government compliance with law. The most widely accepted understanding of the rule of law, which is known as the formalist rule of law, doesn't require much more than this. So for example, it permits laws that discriminate against groups, laws that give the president broad discrimination, those are okay too. What matters is simply the form of the law. So for example, that it's general, publicly promulgated, clear, understandable, and most critically, that the government follow the letter of the law. I'm interested in understanding how this prevailing conception of the rule of law actually helps achieve political accountability for executive branch actions that impact the rights and interests of people of color, especially those communities who are politically marginalized and disfavored within American society. So to explore this question, I'm going to talk about several domestic national security laws and programs that affect the rights of people of color, either or exclusively or alongside other groups. And I'm happy to talk in the Q&A about why I focused on domestic programs. All these programs comply with the rule of law. They are also precisely where we might want to see the power of the executive branch checked. Why? Well, because these programs bolster rather significantly that branch's authority while also undermining individual and civil rights, no matter who's affected. Now, some of these domestic programs have led to popular political efforts to curb executive power. I mean, they've had different levels of success, but there have been broad-based efforts that have manifested. Others haven't really led to any meaningful efforts of political accountability at all, though. And the question I'm trying to figure out is how the rule of law itself influences these outcomes. And based on these findings, to try and figure out how to make law work more consistently, more effectively, in holding the executive politically accountable for programs that threaten the interests and rights of people of color. Why am I focused on the law part beyond the obvious, being a law professor thing? Well, it's because most legal scholars haven't really explored in detail how the law itself influences the horizon of political possibilities and organizing. To the extent that question has been examined by scholars like Derek Bell and John Hart Ely, most prominently, the answer has largely focused on law's relationship to majoritarian politics and to majoritarian politics alone. As Bell and Ely have argued, the politics of the majority, so what the majority effectively wants or doesn't want, undermines minority rights. If you're a disfavored minority group, the majority isn't going to fight for your rights and interests unless their own material interests, whether economic, political, or social, are implicated. But given how socially influential the law is, this seems like a very thin account After all, we live in a society that generally believes in the value of the rule of law, even if we don't always succeed in achieving this ideal. As a result, the law is a critical legitimizing force. If something is lawful, that has real impact on how society generally views the activity in question that may go beyond this whole idea of the material interests of the majority. So I'll spend the rest of this talk describing the basic ways the rule of law affects political accountability when it comes to executive national security activities affecting people of color. And then I'll end by looking at some solutions or some possible solutions to the accountability gap highlighted by some of these circumstances. So in order to cover all this ground, this discussion is necessarily going to be pretty high level. There are certain things I'm not going to talk about. For example, I'm largely not going to discuss the various laws and programs that I mentioned, how they operate, how they comport with the rule of law. I'm happy to talk about these and other aspects of my argument, which, probably not surprising to anybody, I've already laid out in more detail in a law review article I published last year. I'm happy to talk about it, all this more during the Q&A. Okay, so there are three basic ways the law impacts popular political accountability. So first, law undermines political efforts at curbing executive power and protecting minority rights and interests, where the law itself aligns with prevailing social norms and perspectives about a minority group and doesn't negatively affect anyone else. So we can see this phenomenon when it comes to various domestic national security laws and programs aimed at Muslims and Arabs. In the United States, Arabs and Muslims are a small minority community with negligible political power, and that is also a community that is also socially marginalized. Many domestic national security laws and programs disproportionately target this community while bolstering the executive branch's power and undermining civil rights. These programs include, but they're definitely not limited to, but they include the FBI's post 9/11 surveillance programs, which have facilitated suspicionless surveillance that raise significant Fourth Amendment concerns, but nevertheless satisfy the rule of law. They also include federal terrorism prosecutions under the criminal material support statutes. The material support laws prohibit nonviolent activity that in some way, shape, or form supports terrorist organizations or activities. The sweep of these statutes is notorious for its breadth. These laws prohibit things like giving a car ride or a meal to a terrorist, regardless of whether the ride or meal contributes to or causes terrorism. And in fact, these statutes do not actually require the commission of any violent act at all by the terrorist that you supposedly provided material support to. In some cases, these statutes also don't require any intention to support violent acts by the person providing the material support. Across the board, they also carry very steep prison sentences. Like the FBI counterterrorism surveillance programs, the concept of material support has long been criticized on civil liberties grounds, including for violating the First Amendment right to speech and association. But notwithstanding all these problems, these programs also satisfy the rule of law. By disproportionately impacting Arabs and Muslims, these legalistic programs reinforce and legitimize pervasive racist norms within American society about Muslims and Arabs as being predisposed to terrorist activity. These programs reinforce these norms without being explicitly discriminatory or being perceived as such, which, as I'll talk about in a few minutes, is a really important factor. Instead, these laws and programs are facially neutral and can, in theory, target anyone, though in practice they don't. Whether we want to admit it or not, facially neutral laws are a largely acceptable form of discrimination within American society. As researchers have demonstrated, and I quote, racial attitudes most powerfully influence policy views when racial messages are subtle and cues implicit. So despite impacting US citizens, the FBI's counterterrorism surveillance programs, as well as the government's material support prosecutions, have generated little in the way of broad-based political pushback. And this is a result, at least in part, of the fact that they are not viewed as explicitly discriminatory and have mostly targeted Arabs and Muslims in socially acceptable ways. Okay, so this brings us to the second way in which the rule of law interacts and impacts political accountability for the executive branch. So this might seem counterintuitive, but the law facilitates political protection for the rights and interests of people of color, where the law is itself explicitly discriminatory or perceived as such. Even where a disfavored minority group is disproportionately or exclusively affected, explicit discrimination, and by that I mean discrimination that overtly embodies negative views or treatment of a particular group or individual because of their membership in that group. This kind of explicit discrimination is generally seen as socially unacceptable and offensive, at least since the civil rights movement. And of course, there are also trends that reject this general norm. But generally speaking, explicit discrimination is considered to be beyond the pale. As a result, this explicit discrimination, even when embedded within the law, undermines the law's legitimacy and generates social cohesion between disfavored groups and other members of society who are unaffected but still offended by this discrimination. The Muslim ban, the notorious Muslim ban, is an example of this dynamic. So this immigration ban, which was upheld by a divided Supreme Court in the summer of 2018, was issued by the Trump administration immediately after Donald Trump took office in January 2017. The ban went through a variety of iterations and was eventually expanded to include several African countries with large Muslim populations until Biden rescinded the program upon coming to office. So even though the ban disproportionately affected Arabs, Muslims, and Black folks, including US citizens, it generated substantial political backlash that made headline news and contributed to the ban's eventual termination. And most of this backlash focused on the ban's explicitly discriminatory nature and the fact that this explicit discrimination was supposedly out of line with American values. So, third and finally, law also facilitates political accountability for the executive and supports minority rights and interests where it negatively impacts either a large or small but diverse group of people. Even though minorities, including disfavored ones, are affected by these programs, their broad adverse consequence creates a common interest in checking executive action. Now, this may seem a lot like Ely and Bell's account of majoritarian politics, but as I'll explain, it goes a bit further. So an example of a national security program that affected many people is the NSA and FBI's secret surveillance programs, which were publicly leaked by NSA contractor Edward Snowden in 2013. These legalistic national security programs, so programs that had a grounding in the rule of law, affected not only Arabs and Muslims, but also other Americans more broadly. Revelations about these programs generated significant political backlash that eventually led to checks, which were far from perfect, but nevertheless some checks on executive power and support for individual rights. An example of a program that affected a small but diverse group of people is the border wall, which the Trump administration framed in national security terms and tried largely in vain to build. In addition to impacting property owners who were white, the wall's construction affected a cohort of indigenous tribes, Latinx communities, and environmental groups. It was also met with political efforts to curb executive power and protect individual rights and interests. And these efforts represented more than just convergence between the interests of whites and communities of color. That was at play too, but there were also other things at play. In fact, various acts of political mobilization against the wall were led by social justice groups or were the result of alignments between those groups and communities of color. Thanks to this backlash, on the day that he took office, Biden signed a proclamation that paused construction of the border wall. And since then, construction on most of the barrier has been halted. Border wall contracts have been terminated and land has been returned to property owners that have been seized by the government. The Biden administration did actually resume some new construction in October 2021 on 13 miles of border wall in Texas. While the administration tried to downplay this construction, saying it was limited to preventing floods and finishing access roads, even these efforts have received political opposition. All told, these accounts suggest something important about the rule of law's relationship to political accountability when it comes to protecting the rights of people of color, namely that the majority's material interests are not all that matters. Instead, law can overcome the hurdles of majoritarian politics and support political efforts to protect the rights and interests of communities of color where the law violates social norms or affects the rights and interests of small but diverse groups. Okay, so let's talk solutions. If we want the rule of law and political accountability to line up when it comes to minority rights, where does all this leave us? How should we address situations where the rule of law undermines political accountability, makes political accountability harder to achieve for executive national security programs, negatively impacting minority groups? So as I see it, there are three possible solutions to fixing programs that disproportionately impact these communities, but don't affect the interests of other groups or violate deep-seated social norms. The first solution is to call for an end to these kinds of legalistic programs, like the FBI surveillance and material support prosecutions that I mentioned earlier. The second solution is to demand that these programs' civil liberties problems be addressed. And the third is to both address these programs' civil liberties shortcomings and call for them to be applied more broadly across American society. Each of these solutions have pros and cons, but I think, or at least I hope, that the framework I've developed in this talk helps show us the best way forward. So, the first solution, which effectively amounts to abolition. So, ending FBI surveillance and government material support prosecutions is supported by their discriminatory impact. It is also supported, by their civil liberties concerns and the distrust that they have created between law enforcement and the Arab and Muslim communities they largely target. Of course, some might respond to this list by saying, but well, these programs further valid national security objectives, even if they have these really deep problems. And indeed, plenty of people argue that the FBI surveillance programs and the material support statutes are a really important part of the government's preventative approach to terrorism, which has been pretty dominant since 9/11. The material support statutes, for example, do allow the government to intervene before an act of terrorism has occurred, and in particular, prevent the flow of financing and materials like weapons that may be used in terrorist attacks. While there are also significant downsides associated with a preventative counterterrorism strategy, including but not limited to civil rights issues, a preventative approach may not be wholly unreasonable way of addressing terrorist violence, particularly if the costs can actually be addressed. At the same time, abolition may be the only way of addressing the systemic discrimination and accountability issues plaguing these national security programs. Without evidence of explicit discrimination or other socially unacceptable norms, there is little chance the rule of law and politics will combine to limit these programs in any meaningful way. And even if such evidence exists or existed, it's hard to know whether and how such reforms would actually materialize. So this brings us to the second solution, strengthening these programs' civil liberties protections. This could be achieved by, for example, applying strict scrutiny to First Amendment protected activity covered by the material support statutes. In addition, domestic intelligence gathering can be subjected to the Fourth Amendment protections it currently lacks. And it's worth mentioning that this sort of bolstering the civil liberties protections is what most critics of these laws have suggested. But even if such changes can be achieved, the executive branch might still disproportionately apply these programs to Arabs and Muslims. In fact, they probably would be inclined to do so given the history of how these programs have been implemented. And a similar phenomenon can be seen in domestic policing. So while constitutional protections are comparatively more robust than in the national security sphere, there is ample evidence these protections have done very little to prevent policing practices from disproportionately negatively impacting Black and Brown communities. More broadly, where laws disproportionately affect minority groups, rights-based solutions may not be enough to remedy subordination. And this tees up the third and final possible solution, applying these programs across US society. So in a slightly different context, specifically the strengthening of civil rights for non-citizens in emergencies, Professor David Cole made a similar argument for expanding rights burdens across the population. As he wrote, a quote, political process that weighs everyone's security on one side of the balance, but weighs the rights and liberties of only a voiceless and often demonized alien minority on the other, is a recipe for overreaction. A different approach with substantially more hope for taming the time-tested proclivity to overreact in a time of crisis would be to insist that as much as possible, all persons share equally the costs and burdens that we have so often selectively imposed on foreign nationals. Now, while any effort to apply domestic national security programs across American society should be combined with solution two, bolstering the civil rights protections, it may still lead to troubling outcomes. So for example, broad application of the material support statutes would probably mean targeting domestic groups and potentially even expanding the definition of terrorism to reach even more types of activities. Depending on how broad a definition is adopted, it could be twisted to cover the actions of protesters or activists. This would be particularly concerning given the harsh prison sentences that apply to federal terrorism convictions. It would also obviously exacerbate the civil rights concerns that these statutes raise. On the surveillance side, expanding the FBI's practices would mean having the FBI surveil members of all sorts of religious, political, and social groups. Together, though, across the board application of the material support and surveillance programs would likely, again, result in increased policing of communities of color. On the flip side, part of the value of this approach is that broad application, even if it's predominantly to other minority groups, could lead to greater political accountability for these programs and more protections for the rights of people of color. This is an example of this can be found in the campaign to end the NYPD surveillance of Arabs and Muslims after 9/11. This is one of the few examples of successful political organizing against national security programs targeting this group. In order to end the program, Muslim and Arab New Yorkers joined with other minority groups, including Black and Latinx communities, who were subject to similar NYPD practices like stop and frisk. Together, these communities collaborated to pass city council bills that created an inspector general to monitor the NYPD and prohibit racial profiling. Support for these bills was so strong that Mayor Michael Bloomberg, the mayor at the time, vetoed these laws, but was overridden. So the troubling outcomes of widespread application of domestic national security programs could also lead to broader conversations about the problems plaguing the government's counterterrorism activities more generally. And again, we can look to examples of this. Reactions to Trump's threat in the summer of 2020 to designate Antifa, which is a domestic anti-fascist movement composed of a loose coalition of individuals and groups as a terrorist entity, his attempt to do this really generated a lot of conversations. Many rejected Trump's efforts, not only because it exceeded his legal authority, but also for the political and constitutional implications of such a move, including for freedom of speech. While the Trump administration ultimately did not formally designate Antifa as a terrorist group, there have been other calls to expand and apply federal terrorism laws more broadly. These include popular efforts, so grassroots efforts to call for the listing of the KKK as a terrorist organization, and to expand the definition of terrorism to include racism. There have also been bills introduced in Congress to analyze, monitor, and take steps to prevent domestic terrorism. Domestic terrorism has generally been far less central as compared to international terrorism and the government's counterterrorism work. And these efforts picked up even more steam after the January 6th insurrection, but have died down as a result of pushback by advocates and activists who have warned about the constitutional downsides of extending these laws more broadly. As these and other efforts to expand the government's counterterrorism work within American society continue, conversations about the negative effects of the executive's national security powers could accelerate. At the same time, even if these efforts spur reforms to FBI surveillance and the material support statutes, it is entirely possible they will be limited fixes, much like the post-Snowden changes to government surveillance programs by the NSA and FBI. So in short, and thinking about which of these three options would best protect the most vulnerable, it seems, at least to me, like legal fixes are unlikely to solve the problem of discrimination, while the cost of broader applications of these laws are quite high. Given all that, I think the best approach to addressing the ways in which these domestic laws and programs impact the rights of people of color is option one, to eliminate them altogether. Recent activism around policing and the war on terror provides some support for this conclusion. As I'm sure most of you already know, there has been little in the way of accountability for police from either courts or legislatures. Instead, it's been grassroots politics that has achieved the most gains. Much of this politics has called for various forms of abolition instead of reform, because reform has proven to be ineffective, given how deeply riven with racial animus American policing has long been. A coalition of groups working on the war on terror has recently taken up this abolitionist framing and applied it to its advocacy efforts as well. And the coalition is called, amongst other things, for, quote, ending the US war on terror, including the use of the war on terror framework to advance militarism and occupation in countries around the world and in the United States. These grassroots experiences and demands combined with the analysis I've presented today would suggest that abolition is also the best course for national security laws and policies that disproportionately impact communities of color and are similarly dominated by racial bias. Whatever the values of these programs, however broadly they may be applied across American society, they are so deeply shaped by discriminatory norms that reform is really unlikely, I think, to check executive power and protect minority rights. Given that, discussions of reforming or expanding these programs should, I think, be set aside, and conversations about abolition should start taking center stage. Thank you very much, and I look forward to your questions.
Thank you. We are going to start our questions now. And as a reminder, you can send them to me through the chat, and I will then ask them. And I'll start here with our first question is, has there been success in preventing terrorism through these programs? Is that how the national security agencies are justifying the existence of programs that target Muslim communities?
So the government obviously uses or claims that these programs are helping to prevent terrorism in some way, shape, or form. The problem, though, at least in terms of the evidence they point to, is that most of the cases that have come out of the surveillance efforts, most of the cases prosecuted. A lot of the cases prosecuted through the material support statutes don't actually have any connection with any sort of violence. So you have primarily nonviolent activities that are being prosecuted without any clear connection with any effort to actually engage in terrorist violence. Now, there are, of course, some cases where terrorist plots have been foiled, but those, are not material support prosecutions. They haven't also necessarily been a result of FBI surveillance. To the extent that they have been a result of FBI surveillance, they're often entrapment cases. So cases where the FBI has basically suggested the plot to somebody, often to people who are quite vulnerable, and has then swooped in and charged them with terrorism-related crimes. So actually pointing to a true success story that's come from the laws and programs that I'm talking about today, I think it's hard to actually see where those success stories lie, at least on a significant scale. And given the substantial downsides of these laws, I think the fact that any benefit is dubious at best makes us, ought to make us really concerned about the negative impacts of these laws and programs.
Okay. Another question. Have the national security measures in the United States become more refined and focused, less discriminatory, since the events of September 11th? Has the Biden administration shown a movement on narrowing national security measures in the name of civil rights?
So, so I would say that, so there's obviously there are a lot of different national security programs. So sort of take a broader view. I mean, probably one of the most notable things that the Biden administration did was that it paused drone strikes for a while. Now to reassess the program and to see, what sort of consequences it was having, how it was operating. I mean, that was generally a positive development, but then the drone program has resumed. To be perfectly honest with you, I don't know the numbers under Biden in terms of the targeting. I can tell you that, since the program was instituted, at least massively expanded by the Obama administration, the number of drone strikes has exponentially increased through the Trump administration. I wouldn't call that a refined program. I mean, the Obama administration touted it as being a refined program, as being more refined than, say, boots on the ground. But, it's refined from the perspective of an American service member, who doesn't have to go to the region. But of course, it's not refined necessarily when it comes to people who live in the region, who now are dealing with sort of the imminent threat or possible threat of a overhead drone strike, depending upon where they live. So the government, I think, would say, yes, we've become more refined. I think that's a hard claim to justify. What I will say is that there's definitely been a desire, and the Obama administration was particularly known for this, to really ground these programs in the rule of law, to show that they were justified by the law, to demonstrate the ways in which they were legally sanctioned. So that was, sort of Obama's big move away from the Bush administration approach, although the Bush administration also, especially over the latter years, was really focused on trying to show how these programs comported with the rule of law. And of course, we can think of some of the most egregious programs like torture that the Obama administration at least technically eliminated. But a lot of the programs that existed under Bush existed under Obama, existed under Trump, and continue to exist under Biden. I would say maybe, the Obama administration helped to sanitize those programs, perhaps make them look more refined, definitely make them look more like they were grounded in the rule of law. But I don't think substantively they've really changed all that much. The really bad stuff has sort of gone away, but a lot of the programs and laws and all these sorts of things have really remained the same. You haven't seen really much in the way of reform or massive change.
Okay. Speaking of different administrations and their approach to national security, we have a question from John that wants to know about people sticking around and having these bureaucracies where you can have people in place who have served under many administrations, whether they're currently under the Biden administration, under Trump, Obama, Bush. So when you have a situation like that, does it make change more difficult to enact?
That's a great question. I mean, the bureaucracy, is really the big mover in this space. Some people argue that, some people would push back on sort of the political account and say, well, can you really move the executive branch all that much in this space, given the fact that you have a bunch of unaccountable bureaucrats who are largely making these decisions. And it's true that these bureaucrats, or let's call them experts, as some do, exist across, they continue to do the work that they were doing across a variety of administrations. And I think that's one reason why you don't necessarily see a lot of change, at least in the national security space. You see more consistency than you do change, because of the fact that you have sort of a consistent group of people. I mean, it's also a huge bureaucracy, so that's not to say that nothing changes, but at least at the, you have a relatively consistent group of people who are shaping these policies. So that's a factor, right? And then of course, you want to think about the demographics and the sort of the political economy of who are these people, who are the people who are going into the FBI, into the NSA. You have to go through massive security checks. That probably means people of certain backgrounds aren't really able to take on those jobs as well. So that probably comes into play too. But the fact that you have, sort of insulated bureaucrats that are largely making the decisions in these sorts of situations definitely does have a decent amount to do with the sort of challenges facing political accountability in these spaces. To the extent that there have been reforms and changes, they have been quite limited. They've come through Congress. I mean, they've also come through the agencies, but they've come through Congress, the bigger ones, and they've been limited too, right? And Congress is a little bit more subject to political influence than, say, the bureaucrats are. So you can only imagine what it's like if you're if you're more insulated from those sort of political pressures, and you are sort of in the driver's seat for determining what will happen. Is political mobilization going to impact your decision making that much? It probably has to be pretty substantial.
Okay. Another question is, why is there so little law enforcement and political focus on domestic terrorism?
Yeah, I think that's changing, to be fair. I think for a long time, until the last year or two, I mean, the last few years, but especially the last year or two, you didn't see any focus on domestic terrorism at all. And I think, now you do, a little more so than you did before. But I think the challenges that are facing those sorts of efforts is, frankly, embedded within the nature of terrorism itself. And that's the fact that it's a very political concept, both in terms of the way it's defined. Obviously, domestic terrorism is about political violence, but also in terms of the way it's deployed. The way the phrase terrorism, the concept of terrorism, has been used, especially over the last few decades. The word has a much broader, longer term history, but it's really been politicized in the last 40 years or so. is, it's got a very ideological bent to it. And I'm not going to weigh in on who's a terrorist and who isn't. But, accusations of terrorism always have this often have this ideological bent to them. And I think they do in the domestic sphere as well. So you have a lot of political debate, a lot of political pushback, a lot of political resistance to calling groups, people, whatever, domestically, so people who aren't Arabs and Muslims who are supposedly inherently attached to international terrorism, which is how they are often connected and just how the use of these laws are justified in those contexts. People who are, white Americans, non-Arab, non-Muslim, having that term applied to them is going to necessarily cause a lot more domestic political friction than applying it to the international context. So I think that political element both explains why domestic terrorism has not been a real focal point, but also underscores the problems with the concept of terrorism more broadly, how we use it.
We have several questions coming in about what would happen if these programs were abolished. And one context that was given is in regards to the January 6th event at the Capitol. And if the programs were not in existence, could that affect prevention of such an event happening? And, how would we keep the nation, quote unquote, safe from terrorism if national security programs like this were not in place?
Well, how do we keep people safe from crime generally, right? There are all sorts of tools that law enforcement agencies have that are not as expansive as these laws and programs, and already give the police quite a bit of power to investigate, surveil, and prosecute individuals. So these laws are not, shall we say, they are laws that are and programs that are extreme by design. And I think there are real questions, as I mentioned in response to one of the earlier questions, as to whether or not they've been effective at all. So, January 6th, the sort of mobilizing that was happening on January 6th, my understanding is that, it wasn't a secret, that this was happening, right? Why do you need broad FBI surveillance powers that effectively allow the FBI to go in without any suspicion of wrongdoing and, surveil communities and religious spaces and other kinds of spaces? Why do you need that? When, for example, when it comes to January 6th, there was plenty of suspicion-based surveillance that could have happened. You also, again, I don't know that you need material support laws to do anything about January 6th. There was plenty. Aiding and abetting is a concept that exists in the law generally. The material support laws take out, there are aiding and abetting laws that strip away some of the limitations of aiding and abetting, but they are effectively aiding and abetting laws. So you can use the aiding and abetting concept, right, to actually target people who have truly criminal liability for what's happening, as opposed to, I wouldn't actually think it was a good idea to say prosecute someone who gave a ride to somebody on January 6th and brought them to the Capitol. I don't think that's appropriate. I say, prosecute the person who was involved in January 6th, absolutely. But even if that person knows that the person was up to no good, I think it is quite an expansion of our concept of liability to throw that person into prison for 30 years for giving someone a car ride. So I don't think that these laws and programs have been central to, protecting the country from terrorism. And I definitely don't think that we need them, given a host of other tools that exist. And, when these laws were passed, when the two primary material support laws were passed, 18 U.S.C. 2339A and 2339B, they were met with a ton of backlash, including from people inside Congress. some of those laws had actually been proposed earlier in the 80s, and they couldn't get out of Congress because they were politically incredibly unpopular. But then the world changed a little bit in the 90s, and advocacy groups got their act together. You had things like the World Trade Center bombing, you had the Pan Am flights, you had Oklahoma, and suddenly it became politically viable. The politics changed more so than anything else. And then those laws were passed, not necessarily because they were necessary, but because, from a political standpoint, they were expedient.
We did have someone also asking about the material support statutes. And they write, what sort of progress has there been regarding legal attacks, as opposed to political attacks, on national security statutes with overly broad reach, such as material support statutes and the like?
Yeah, so I mean, the big case that tried to go after the sort of broad sweep of the definition of material support, and in particular, the liability structure for Section 2339B, which is the most problematic of the material support laws, failed. It ended up in the Supreme Court, and in 2010, in Holder versus Humanitarian Law Project, the Supreme Court said, these sort of civil rights attacks, First Amendment based attacks against the material support law aren't going to stand effectively, because here, these were, by the way, groups that had brought a motion for a declaratory judgment about the constitutionality of this law. They were NGOs and humanitarian groups that wanted to work with designated terrorist organizations to help them, actually ground their arguments in the law. So the Humanitarian Law Project wanted to work with a Kurdish group that was listed, the PKK, which was listed or is still listed as a terrorist organization by the State Department, to help them with their legal advocacy efforts in front of the UN to achieve self-determination for the Kurdish people. And they were worried they would be prosecuted for this under the material support law. So they brought a case that went through the Ninth Circuit and then to the Supreme Court, challenging this law as unconstitutional. And they lost because the Supreme Court said, effectively, you would be doing this in coordination with a terrorist group. And so because it was in coordination with a terrorist group, it was okay. It wasn't First Amendment protected activity, and it was okay for Congress to prohibit this activity. So, I mean, the Supreme Court left the door open as to whether or not, situations where there was no coordination, where, for example, a group just wanted to go out and advocate on behalf of a terrorist organization, whether that would actually be constitutional under the material support statute. But, at least in the situation where you're working with the group, even if it's to provide them educational services, legal educational services, not educational services on how to build a bomb, the Supreme Court said that that's a perfectly fine thing to be prohibited by Congress, and that there didn't need to be any intent to further terrorist violence, which of course the organization had no intent of doing. That intent, which Section 2339B doesn't require, was okay not to require it.
Okay. We have a question from Dean Johnson around an area. He has a lot of expertise about the term illegal aliens. Are the use and function of stereotypes about terrorists similar to the use of stereotypes of illegal aliens? President Trump relied on these stereotypes in making national security and immigration policy.
Yeah, I think so. Absolutely. That there are that assumptions and biases and stereotypes about those groups, whether they're illegals or Muslim terrorists, have a well, for some people, right, there is this idea that there's explicit discrimination that those kinds of ideas reflect. So in some ways, it does really depend on who the audience is. But for others, especially I think where the suggestion is a bit more subtle, I think when you have a more explicit sort of, people from these blank hole countries and all of that, I think that does sort of rise to a level where the rhetoric, broadly speaking, is less effective politically. So you have stuff accused that are a little bit more subtle about the threat from immigrants, that those really resemble the sort of racial animus I'm talking about when I reference these laws. It's all very complicated and in flux, right? American society it feels like it's at an inflection point. And so it's entirely possible that 10, 20 years from now, this embrace of these explicit discriminatory norms will come back as being an okay thing. But I think for now, even sort of explicitly racist terminology about immigrants does serve to sort of raise the hair on the back of a lot of folks' necks, and ultimately is a little less politically effective. So I'm thinking about a lot of the family-based separation, a lot of the things that Trump did, right, around immigration, around separating families, that was really explicitly offensive to a lot of people. When the Obama administration did things that were more similar, they were not couched in the same language at all that the Trump administration used. And of course, he also took measures that were different from the Obama administration. But, largely there were similarities between the policies, and you didn't really see the kind of pushback you saw when Trump was doing it. We could say maybe it's the person of Trump, but the person of Trump, separated from a lot of the racist language he uses, I think is a hard thing to do.
As we're concluding our event today, what would you tell us to watch as we're moving into the future around these programs? Are there legislative movements happening, or other advocacy that you are watching and that you might recommend we keep an eye on?
So there are these bills that are pending in Congress, although they haven't really moved forward, that were attempting to expand, for example, the material support laws into the domestic sphere. I hope those laws don't go anywhere, and for now it doesn't seem like they will. But much like with the material support concept in the international sphere, it came back over and over again until it finally stuck. So I would expect to see these laws reintroduced if they don't pass this session. So I think that's something to watch, and generally not to be a fan of. I'm particularly interested and excited about this sort of slow burgeoning movement amongst some groups who are, focused on the war on terror and want to abolish it. I think it'll be interesting to see how their efforts materialize. They've just really started focusing on applying this abolitionist lens to the war on terror, so it's early days. But I think if they are able to engage effectively with other groups, other minority communities of color, and other social justice organizations, it would take a lot of time, but I think we could potentially see something that's that bears a little bit more fruit than what we've seen so far. And in case anyone's interested in these efforts, it's led by a group called Justice for Muslims Collective. If you look them up and you sort of Google abolition war on terror, you should come to a webpage that actually has their platform listed. So that to me is the most positive and interesting thing that's coming out right now. And out of the space.
Great, thank you.
Well, thanks, Professor Jamshidi, and thank you all for being here. Stay tuned. We'll be continuing our Racial Justice Speaker Series later this spring. Thanks again to everybody.
Thank you so much. It's been
Take
great.
care.